this Senate hearing on motion to dismiss back in session, and it's approximately 1:36 p.m. in the afternoon. Members are seated, and with that, at this time I recognize the representative or the respondent to present your testimony today, and please state your name for the record. So.
Read is correct? Check. Okay. Before I begin, I'd like to thank the senators for allowing our people who just commented to speak in their native tongue. And I would also like to note that none of the House members who made comments this morning opposed to any of the article's constitutional violations. Good afternoon, Senate President, honorable members of this august body. My name is Anthony H. Uggan, and I am here today on behalf of my client, Ralph Anthony de Leon Guerrero Torres, along with my co-counsel, Gilbert Burnbrick. And on behalf of the governor, I would first like to thank you for allowing us the time to finally address the articles of impeachment that the House has illegally filed against the governor and has been wrongfully trying in the media, while at the same time failing to make any of their arguments in the proper form, which is here before you. The CNMI Constitution, which is the highest law in our great Commonwealth, bestows upon the Senate the power to try and impeach the official and the responsibility to ensure that the impeachment process strictly abides by the law. The decision that you make over the next few days will not only affect the governor and his family, but it will affect everyone here living in our islands. This is no doubt a monumental task, and so I thank you for giving it the time and attention that it truly does deserve. I would like to begin my presentation with one number, 62. That is the percentage of voters in the CNMI who chose Ralph Torres as their governor in 2018, the highest percentage of votes in CNMI's history. He's the only elected official ever to win in every precinct of every single island in the CNMI, from Rota to Tinian to Saipan, all the way up to the Northern Islands. And the election of a public official is a direct reflection of the will of the people. In 2018, around 9,000 voters spoke out loud when they elected Governor Torres into office. And that is why I must stress today how extraordinary this impeachment process truly is, because it could undo the will of our people. And although impeachment is a political process, it cannot be a lawless one. It still has to comply with the law. And if ever the House violates those laws, then any of their acts should be declared null and void. Otherwise, the House could recklessly use the impeachment process and completely disregard the will of our people. Honorable members of the Senate, that is exactly what the House has done here. All of the articles of impeachment lodged against Governor Torres repeatedly break the law. And any one of these violations, and to be clear, they are not technicalities, they are direct violations of the law. Any one of them that we're about to go over today justifies dismissal of the articles in their entirety. So with this motion to dismiss, the issue before you is not about whether Governor Torres should be impeached. We aren't even there yet. Rather, it's about the fact that to do so, it must be done correctly and constitutionally and follow due process. We are a nation of laws and not men, and the rule of law must be followed. And to be totally clear, only the Senate has the authority to rule on this. Under the Constitution, the House charges an official with an impeachment, and the Senate acts as the court and tries the official on those charges. So the Senate is our only gatekeeper to ensure that the impeachment process follows the law. And when an impeachment violates the law, only the Senate has the authority to strike it down. Okay, let's get into the first major violation. The CNMI Constitution specifically limits the sanction that the House could seek on an impeached official. If an impeached official is ever convicted by the Senate, the only sanction available under the Constitution is that official's removal from office. It is illegal for the House to seek anything more. Here, the articles brought by the House don't just seek to remove Governor Torres from office, but they also unconstitutionally seek to impose a greater penalty by demanding that Governor Torres be disqualified from holding any position of honor or trust in the CNMI. If granted, this would effectively eliminate Governor Torres from running in the 2022 election or ever again. And despite being a direct violation of the Constitution, the articles require this penalty not once or twice, but a total of 6 times. And this is not something that the Senate can cure. The Senate cannot amend the articles by erasing the illegal penalties, because that would encroach on the House's constitutional authority to bring impeachment charges. And even if the Senate could fix them, all the articles should still be dismissed because the House did not include a severability clause. A severability clause is basically a tool that allows us to uphold lawful provisions of a document and disregard unlawful ones. It is undisputed here that the House chose not to include a severability clause in their articles. And so that means that the House meant for all of these articles to either operate altogether or none at all. Besides seeking unconstitutional penalties against the governor, the House also repeatedly violates due process laws throughout the impeachment process. For example, due process requires that the House follow its own rules, and the House did not do that here. Instead, it rushed to judgment to get these articles passed, regardless of whether or not they were breaking the law. Let me show you how. The whole impeachment process began when the cabal of House members led by Selena Babauta and Tina Sablan pre-filed the articles in the House on December 20, 2021. The very next day, the House Speaker created a special committee on the impeachment and vested it with investigative power, which includes the power to subpoena witnesses and evidence. Only 2 weeks later, the committee held its one and only meeting on January 4th, 2022. And there it adopted a one-page set of rules and voted to prepare a committee report to refer the articles to the full House. The committee concluded its meeting, and that was the end of their entire investigation. Under the House rules, the committee had a duty to make a diligent and careful inquiry and investigation into all of the facts and circumstances that are connected to the impeachment matter, and also to report its recommendation on the impeachment to the full House. Here, the special committee failed to conduct any investigation, failed to issue any subpoenas, failed to call any witnesses, failed to take any testimony, failed to require the production of any documents or evidence, and even failed to officially adopt any testimony or evidence from the JGO. Based on all of these failures, there's no question that the Special House Committee failed its duty to conduct a diligent and careful inquiry and investigation. This is a direct violation of the Constitution, not a technicality. The House rules also required the special committee to submit a written report with the findings of fact, conclusions, and a specific recommendation as to how to dispose of the referred matter. Here, the committee's report contains none of these things. And importantly, the report failed to make a specific recommendation on how the House should address the articles. Instead, it simply recommended that the full body of the House decide on the next course of action. Honorable members of the Senate, these are undisputed violations of the House rules. They are not technicalities. And make no mistake, the House was well aware of them. Congressman Patrick Nicholas, Angel Demopon, Lee Pon, Joe Flores, and Roy Ada, they each raised this issue at the House's hearing on the articles of impeachment. Congressman Nicholas even went so far as to request for a completed report on the articles before making any decision. However, all their voices were ignored, apparently because it didn't fit in with the other representatives' plans. In fact, no other House member inquired on the committee's failure to comply with its duties. This is all proof of the House's rush to judgment, sidestepping the law to pass the articles, apparently in response to the lawsuit that rightfully challenged the JGO subpoena on Governor Torres. And it was also apparently to eliminate the governor as a candidate in the 2022 election. This substantial failure to follow the rules in and of itself warrants dismissal of all of the articles of impeachment. And as if those violations weren't enough, the special committee also failed to comply with House notice requirements at its only hearing. At the hearing, the committee unlawfully took final action on their committee report because the report's adoption was not on their agenda and no motion was made to adopt the report after it was prepared. At the same time, the special committee also violated the Open Government Act by failing to issue any notice of meeting to adopt the committee report after its adjournment on January 4th, 2022. And it also failed to conduct a record vote to adopt the committee report. Totally separate is the fact that the House JGO also repeatedly violated the law when it conducted its investigative hearings. Specifically, the House JGO illegally overstepped its subject matter jurisdiction, which does not include conducting an impeachment investigation of an executive official. There is no other reason why the Speaker created a special committee, granted it investigative power, and referred the articles of impeachment to it. That can only mean that the JGO did not have the power to do so. The JGO investigations also illegally encroached on a number of subject matters that were assigned to other standing committees. For example, the JGO illegally spent an enormous amount of time investigating the governor's use of public utilities, which are subjects within the jurisdiction of the Public Utilities, Transportation, and Communications Committee. The JGO also spent a significant amount of time investigating the governor's reimbursements for expenditures. These are subjects within the jurisdiction of Ways and Means. I must also mention here that the JGO's investigation essentially had the same function as a grand jury, which is not only illegal, but a direct violation of the separation of powers of our Constitution, because grand juries are a sole function of the judicial branch. Honorable members of the Senate, any one of these violations render the articles of impeachment null and void and justify their dismissal in their entirety. Now, at this point, I would like to address a big elephant in the room. And I'm not talking about the Republican Party. I'm talking about the fact that I am here today on behalf of Governor Torres, ready to address the articles of impeachment with a motion to dismiss that was properly filed before you. And where is the House? Not only has the House failed to make a proper appearance, they also failed to properly submit their impeachment record or any evidence at all in support of the articles of impeachment. And as we see today, they have failed to make any proper argument against this motion to dismiss. All my arguments, senators, are unopposed. And it is obvious why. Because the House knows that they failed to follow their own rules then, and that they are failing to follow the Senate rules now. And last but not least, the articles directly violate the Constitution, the Government Ethics Act, and the House rules, all because of one person's participation throughout the impeachment process. Representative Tina Sablan. Our CNMI Constitution prohibits a legislator from participating and voting on any legislation matter when she has a financial or personal interest, and also requires disclosure of that interest. The Government Ethics Code prohibits a legislator from using her public position to obtain a personal or private advantage. And finally, the House rules prohibit a legislator from voting or participating in the debate of any matter in which she has a financial or personal interest. The rules also require disclosure of any conflict of interest. Honorable members of the Senate, it is undisputed here that Tina Sablan's participation and influence in the impeachment process directly violates the law because she has a personal interest in the impeachment of Governor Torres. As a gubernatorial candidate in 2022, Governor Torres is Tina Sablan's biggest opponent. Tina also violated the law because, unlike Senator Vinnie Sablan, Tina failed to declare this conflict. And despite the apparent conflict of interest, Tina Sablan's extensive participation and influence on Governor Torres' impeachment is well documented and throughout. On or about January 6, 2021, it was Tina Sablan who submitted to the 21st House a minority report that investigated Governor Torres' expenditures. On May 28, 2021, Tina Sablan asserted without reason that the report be included in the records of the 22nd Legislature and be expeditiously referred to the JGO. Only 6 days later, the Speaker referred that report to the JGO as Tina Sablan suggested. The JGO thereafter commenced its unlawful investigations into Governor Torres, which generated months and months of free publicity and media attention for Tina Sablan. On or about November 1st, Tina Sablan declared her candidacy for governor. She did not disclose at this time, and so every action after this declaration is undoubtedly unconstitutional. At a hearing on December 10, 2021, it was Tina Sablan who announced that the JGO would not hold the governor in contempt for failing to appear, and that if the governor did not appear on December 14, I quote, the committee would vote to cite the governor for contempt and refer the matter to the Attorney General for prosecution. On December 17, 2021, Tina Sablan and 13 other House members prepared and pre-filed the articles. This is only 3 days after the governor filed a lawsuit rightfully challenging the JGO subpoena. On December 20, 2021, Tina Sablan was one of the House members who introduced the articles to the House floor. On December 22, 2021, the Speaker formed a special investigating committee for impeachment and appointed Tina Sablan to it, even though he knew she was a gubernatorial candidate. And at that time, Tina Sablan did not recuse herself. On January 4th, 2022, Tina Sablan and the special committee voted to refer the articles to the full House. And only days later, the House accepted the referral. And at a House session that same day, Tina Sablan voted along with 14 other House members to pass the articles, which not only called for Governor Torres' removal, but also illegally sought to bar Tina Sablan's biggest rival from running in the 2022 election. As you can see here, Tina Sablan has been a driving force throughout the impeachment at the House. As a candidate for governor, her repeated participation in the impeachment process is a direct violation of the Constitution, the Government Ethics Act, and the House rules. And this is yet another direct and unconstitutional violation that justifies the dismissal of the articles of impeachment in their entirety. And as if her personal interest wasn't enough, Tina Sablan's participation and influence in the impeachment process is also illegal because of her financial interests. This impeachment has garnered a huge amount of media attention and has undoubtedly provided and continues to provide Tina Sablan with a free campaign platform for her candidacy. All the while, this stage drama is being paid for by the taxpayers. To be clear, this media attention is a direct savings for Tina Sablan, the Democratic Party, and their 2022 campaign. Tina Sablan also has another financial interest, which is the salary increase that she stands to receive if she is elected governor. As a House member, Tina Sablan earns $32,000 a year. As a CNMI governor, she would earn $120,000. This means that Tina Sablan stands to receive a salary increase of $88,000 a year, which over the course of 4 years is $352,000, over $250,000. This is yet another conflict of interest which prohibited Tina Sablan from participating and influencing the impeachment process. Yet she did, extensively, and it is undisputed that she did. And so now the only way that the Senate could fix this constitutional violation is to dismiss all of the articles in their entirety. Honorable members of the Senate, I began my presentation with a number, and I would like to end it with another one. 0.1, a 0.1%, which represents the percentage of the 15 House members as voters who are recklessly trying to undo the will of 62% of the voters here in the CNMI. Based on all of this evidence that I presented today, undisputed, unopposed evidence, it is abundantly clear that the House's repeated violations of the law are not mistakes. They are a pattern, all in support of their quest to impeach Governor Torres and remove him from the 2022 election. And the House has carelessly wasted an estimated millions of dollars of government time and resources all along the way. As the CNMI's only gatekeepers on impeachment process, it is the Senate's duty to ensure that the impeachment process follows the law. And when the House conducts an impeachment that repeatedly violates the law, only the Senate has the authority and the responsibility to call them out on it and strike them down. The House should not and cannot be allowed to use this impeachment process carelessly and recklessly. Accordingly, I ask this honorable body to do what is right and just and send a clear message to our people that no person is above the law. Si Diyos Masi, Kiliso, Salamat po.
Cool. You good? You have any?
I have no comments today.
Thank you. Thank you, Council Ogun, for your presentation.
Thank you, Mr. President.
At this time, the chair wish to allow members of the Senate to pose a question with regards to the presentation by the counsel for the respondent, in this case, the impeached official. So any member I would like to recognize now. Recognize Senator Manglonia.
Thank you, Mr. President. First of all, Mr. President, before I address some of the comments by Attorney Ogun, I just want to ask the members, and most especially our legal counsel, as to the statement made by several House members pertaining to Rule 19 of the impeachment. Is it true that this motion to dismiss is time barred pursuant to our rules? Is there a legal opinion on that, or can we hear from our legal counsel on that first before I have other concerns? But maybe that's the first one that I think we should address at this moment before we proceed.
Thank you. For the question, I'll recognize Council Villagomez.
The Rule 19 discusses the legal sufficiency of the articles of impeachment. I believe the House is misinterpreting this rule. The rule basically says, Rule 19 basically says that the impeached party may file a motion to dismiss within 14 days prior to the commencement of the articles of impeachment hearing. In this case, we haven't set yet that hearing date. The 14-day calendar days basically says if in case the Senate sets a hearing date, the impeached party has up to 14 days or within 14 days prior to the beginning of the hearing to file their motion to dismiss. In this case, the impeached party filed their motion to dismiss, I believe, on March 28th, which is not time barred because we have not set the commencement date of the articles of impeachment hearing. So they are in order in this case.
Comment?
Senator
Okay.
Magnolia, you were
Yes. Mr. President, so this is, I guess, maybe I'm not understanding it clearly. This is not an impeachment hearing today. Today is not an impeachment hearing.
it's motion to dismiss hearing. It's not necessarily direct impeachment hearing.
Okay, so it's not an impeachment hearing. Well, Mr. President, first, I want to disclose something that maybe not many are aware, and I don't even know whether I should be discussing this in this chamber. I believe before lunch today, I filed a motion to intervene in the Governor Torres case versus the JGO. Also, a motion to temporarily put a restraining order on the hearing, which I don't know whether this is a hearing or what, but basically my motion is to bar this uh, meeting today. I'm not a lawyer. I did this pro se with Carmen Patricia de Leon Guerrero. We did it because we're just concerned that if there is a hearing, then as mentioned many times by Attorney Hogan, we have to act as a court. And for some reason, under the Constitution, the Senate is supposed to be the jury. And I don't know how I can act as a jury, as a juror, if there's no prosecutor and we only have the person being accused. So that's why I wish there's the House is here at least, or since this is not a hearing and it's not very formal, from what I'm hearing, it's not an impeachment hearing. At least for our benefit as public servants, we ask the House Counsel to come in here and defend themselves, because this is all legal matter. I hear, for example, for some reason, I almost think that this is impeachment hearing of Tina Sablan, because there's a lot of accusations against her, and I wish we can just bring her in and answer to those accusations, or her lawyer, or all the ethics violation, because these are all legal discussions, and I am not a lawyer, and all of us, none of us in this body is a lawyer. And for example, about written report, it's in the rules or in the law, or I don't know where is that requires the impeachment committee to provide. I understand, that the JGO did an extensive public hearing. It was live, it was
Senator Magdalena,
open.
may I request that you pose your question to the council? You got the floor to pose your question.
Okay, so I'm just saying that before we even go to that, I'm just saying that I guess I'm questioning the meeting today, the purpose of this meeting. If the other side that's being accused is not here to respond, and with all due respect, Attorney Ogden, right, you make some good points. For example, severity clause. I really want to know, because this is not only about this governor, where this is going to be in history, down in the record books, right? And if in the future lawmakers decide to impeach another governor, we want to know. I don't know that a JGO can conduct months of hearing, and they cannot just transfer that to the special impeachment committee, who then can do the same thing and start over with the same members, basically, maybe more than 50% of them are the same members. They participated maybe in their offices listening to the process, and then they cannot just adopt it. So basically, my understanding is they adopt it. So is that a legal issue? I'm not sure. And then you're mentioning about the penalty that they impose. I guess that the governor can run. I may not agree also to that, but I don't know that the Senate cannot overlook that and impose a lesser penalty. If that's the case, I really don't know. Those are legal questions, and but the most important legal questions that I have today really is under the Constitution. When the House impeaches a public official, the Constitution says you have to have a hearing. So for me, I agree the separation of I guess branches, but for me, it's a constitutional requirement, and I think that the Senate or we're counterparts of the House, we should welcome anything that is brought before this body that will do good to the community, to the public, and to the way we provide services and programs to our people. So
Senator?
I welcome the House of Representatives.
Senator Manglone, may I interject? Because other members would like to, they're raising their hands. So if you're going to pose your question, I ask that you post it now.
Okay, so my question is, or it's not a question, it's I don't know. I don't want to participate in this kind of forum where we're supposed to have one party, argue their point, their articles of impeachment, the other party defend it. I want that to happen, and then let's listen, and then we, as elected official, will decide. That's
Okay,
all
thank
we want.
Thank you, Senator Paul.
Thank you.
I want to recognize, before I recognize Mr. Ogun, I see Senator Carl.
Thank you, Mr. President. First off, if we could just get clarification from legal counsel whether today's proceedings fall under is an actual hearing on the motion to dismiss and is a part of the impeachment.
Yes, I think I already said that this motion to dismiss is in order pursuant to the Senate impeachment rules.
Okay. Now, so it's clear that this is already a function of the impeachment in the form of a motion to dismiss hearing. Secondly, I too would like to have the House here. We gave them ample opportunity. One of the things that was said today was that they thought that they had their rules in order. Now, there was no communication, to my knowledge, from any of the House members or the House Speaker with regards to issues with the rules. If they had any questions or concerns, they could have made them very clear and known so they could get guidance so that the version that they submitted wasn't so horribly arranged. So I push back against this notion that we have somehow prohibited them from participating randomly. It was very simple. How does a document start? In the rules, it says it has to be consecutively paginated. How do you start on page 7,000? How are you missing 3,000 some odd documents? It has to be, there's transcriptions. None of them were provided. Some of the exhibits were stamped, some of them weren't. So are we supposed to go on in good faith that this is the evidence that you're providing? Again, this is all part of what we're requesting, and it wasn't outrageous. Nobody brought any issue up to include the minority members in the Senate, to include the majority in the House. Nobody had any concerns. So if there was any questions regarding the evidence and the records, they should have been made clear.
Thank you, Senator Carl. And before again, I recognize Mr. Algon, Senator Cruz.
Thank you, Mr. President. I thought the legal counsel stated that we're in order. The House is supposed to be here, but all of them declined to be present today. And we are following the due process of our rules. It is not we're not hiding anything here. We're in order here. We wish they're here, but they all declined to be present to present their case. So the question is that you raise, Senator Manglonia. It is their fault why they're not here. I wish they're here so we can hear from them too and present the case. And like what I've mentioned earlier, it's in the rules. They have to present to the Senate their evidence that has to be in order. We're not the one to arrange their evidence to be in order. It took them 1 year to investigate this case. And those evidence could have been in order from the start. They know that they're going to present to the Senate to prosecute their case. There's no reason why they're not ready to present their case. I wish they're ready so that we can hear from them. But today, we have to proceed with the process of our rules. And whoever present or willing to come forward to the Senate to present or either defend the articles against them, we will entertain them. We're not just going to ignore. I believe that if they have a 7,000 evidence, I'm pretty sure that they can, even though it's only one prosecutor, they have to be confident of their case. We have 7,000 plus evidence why they're not here, because they declined to be present today. So we're not going to keep arguing back and forth as to why they're not here. It's not fair. It's their fault why they don't want to show up. We didn't force them not to show up. We gave them the opportunity to come to the Senate and present their case. So like the legal counsel have said, we're in order with this hearing. Thank you, Mr. President.
Thank you. Before I recognize Senator Cruz, thank you. Before I recognize Senator Edith, I believe the council raised his hand earlier before I even recognize Senator Carl. So I'll go ahead and Council Logan.
Thank you, Mr. President. I just wanted to discuss some of the stuff that Senator Paul just raised. The first was the House misinterpretation of Senate Rules 19. That is another example of this pattern that I'm discussing to you. The rules don't apply when they don't want it to apply. And with an impeachment process that is so important and so extraordinary, these are the type of things that we cannot have done. And in the legal process, there's this thing called a default. And a default happens when a party fails to comply with the rules. When they fail to comply with the rules, the courts treat that essentially as admissions. That's why I keep telling you, all of my arguments today are unopposed. They're undisputed. Because it's the House that failed to follow the rules. We're here today ready to argue, ready to represent Governor Torres. And it's the House that failed. They failed to follow the rules and make these arguments, Senator Paul, that you're asking for. They could have opposed any of my arguments. And regarding which rule I'm citing to, if you did read my motion to dismiss, I spell them out clearly for you. But if you would like to ask specifics, I can go about them today. I can talk to you about them today. Thank you.
Thank you, Council. I recognize now Senator De Leon Guerrero.
Yes, thank you, Mr. President. I'm not going to sit here and discuss about the lack of prosecutors. We understand that they're not present and they're not allowed. I also understand the 62% of voters, which you called out, Attorney Ogden. I also took notes of the 2018 9,000 voters and so forth. But that's not my question right now. I want to get back to the legal counsel of the Senate. And so we say we are in order. My question is this a judicial process or a legislative process? That's one question. If I may just get a quick reply, and then I'll move on to Rule 19.
This is a process within the Senate, and it's a process pursuant to the Senate rules.
Thank you. Now, if I may read Rule 19, it says, and it's entitled Legal Sufficiency of Articles of Impeachment. Any motion to dismiss or legal challenge to the sufficiency of the articles of impeachment or any portion thereof must be submitted in writing to the presiding hearing officer within 14 days, 14 calendar days, prior to the day set for the commencement of the hearing on the articles of impeachment, or as permitted by resolution adopted by the Senate. And it moves on to 19A, the presiding officer, the hearing officer shall set the date and time for a hearing on any motion. So it seems to me, in reading this in plain English, that first the presiding officer must set the day for commencement of the hearing. And then when that day is set, then the defendant, in this case, Governor Torres or his legal counsel who's representing him, must submit its motion to dismiss or legal challenge to the sufficiency of the articles of impeachment 14 calendar days prior to that, which is before the day set, right? So if today is, let's say April, let's say that we set the date for April 20 as the commencement of the hearing, right? Commencement of the hearing. 14 days before the 20th is whatever that day is. Correct? And that's the day that allows the defendant to submit their motion to dismiss or legal challenge to the sufficiency of articles of impeachment. I Googled during break, had a sidebar conversation with other senators, and out of curiosity, yeah. It came up and it says, when can a motion to dismiss be filed? And it says here, a motion to dismiss can be filed at any time. So it says that. But this is our rules. We are very specific that it says it must be filed in writing, submitted in writing to the presiding hearing officer within 14 calendar days prior to the day set for the date. That means the day set must happen first before the filing of the motion to dismiss or legal challenge to the sufficiency of the articles of impeachment. Am I interpreting this erroneously? Am I not reading the English language correctly? And having my analytical understanding of what I'm looking at right now, am I not interpreting that correctly? I like to be proven wrong. Thank you.
I'm reading the same thing, Senator, and I understand your interpretation, but the intent here, when the rules were established, is to establish a deadline or a cutoff when the motion to dismiss can be filed. So you correctly stated, you were right, that a motion to dismiss can be filed at any time, and then pursuant to Rule 19, it can be filed any time within the 14 days prior to the set of the hearing date. And so that is how the rules were drafted and intended. The 14 days basically was supposed to be a deadline. So you can file as soon as the impeachment official files his appearance and answer. Anytime after that and prior and within the 14 days prior to the set of the commencement of the impeachment hearing, the official may file a motion to dismiss. Now, anytime after, if it says 14 days before, so if it's before the commencement, then they can't file the motion to dismiss. So I understand the way you're reading it, but the intent when the rules were drafted is to establish this 14-day as a deadline or a cutoff for when the motion to dismiss can be interpreted. So I don't know how else to explain it, because that was the intent when the rules were drafted and was discussed, and that's how it was thought out. Yeah, I apologize if it reads, if it's a little bit confusing when you read it, but that is the intent and that is my interpretation.
Can I? Please?
Senator,
Okay, so let's work the calendar clock here. What's today's date? April 19. The motion to dismiss was filed when? March 28, 2022. 14 days from March 28. Within, right? That's what the rule says. Or prior to the day set. Would have taken us to April 10, 2022. Exactly 14 days. Are we saying today that that is the supposedly set time date, but we are already on April 19, 2022, conducting this exercise to hear the motion for dismissal? Yeah, this is where now all the legal technicalities kick in terms of interpretations. Thank you.
thank you, Senator Leongoro. I see Senator Vic raising his hand. Recognize.
Thank you, Mr. Chairman. I thought that today's meeting is to allow the respondent counsel to hear their motion for dismissal, and after presenting their motion, that the chair would then schedule a formal date for the specific hearing to commence. Is that this meeting today? Well, so basically today's meeting here is just to hear the motion for the respondent's motion for dismissal. Not necessarily that we begin the official hearing dates for the respondent.
I think if there is an assumption that we're going to be making a decision today based on the presentation, that's not going to happen.
If I may continue then, Mr. Chair. So today's hearing for motion to dismissal, the members present must take action before we move forward for a formal hearing. Is this the intent of this meeting today, to hear the motion for dismissal?
Again, we're listening to the presentation as filed by counsel from the respondent on why or the reasons to consider dismissing.
So we're not bound to make that decision today, whether we will move forward with the hearing until the chair set a date for the hearing to begin.
That's correct, Senator. And again, this is motion to dismiss as filed by the respondent's attorney, of which that would trigger a session to entertain what transpired, what we gathered today for consideration. It's not going to take place today. But to your question, before I allow you to continue on, if you don't mind, I'll recognize Senator Carl, who keeps raising his hand in the back.
Thank you, Mr. President. I just would like to clarify with legal counsel. So it's clear that 14 days the 14 day is triggered by the setting of a hearing date. Is there anything that prohibits us by the rules from hearing a motion to dismiss prior to setting a hearing date?
No, not pursuant to Rule
Thank you.
19.
I'd like to follow up just along that concern.
Before I recognize Senator Maglonia, I think I asked Senator Hope to
Well,
reserve his time.
That's exactly my point, Mr. President. That today's particular meeting with the respondents' counsel is for us to hear them, and then the chair would call a session for the senators to take action whether or not the motion for dismissal will be granted or denied before the schedule. Before the chair would schedule a hearing 14 there, moving forward from there.
You got that clarification now?
Is that correct?
Well, yeah. I mean, I'm asking you if you got that clarification squared.
Well, I just want to make sure that I am in the same track with
Okay.
the concern that was being raised. So
Thank you.
if there's no action for the senators that are present today, whether or not to move forward with the hearing in the absence of the chair holding a session to have the members vote whether or not the motion for dismissal will be granted or denied, then I'm satisfied with the explanation of the chairman. Thank you.
Thank you, Senator Hoku. And Senator De Leon Guerrero.
Thank you, Mr. President. Still on that rule. And if I hear it correctly, what Senator Carl had asked the counsel of the Senate, that it does not restrict any other future motion to dismiss hearing prior to the day set, which is still absent as we speak today. So my question is, are we anticipating, I know you already ran on record, Mr. President, that we're not going to make a decision today with what we're hearing from the defendants' counsels. So are we doing this today and then maybe expect another motion to dismiss engagement like this prior to that day set? And maybe 14 days before that day set, we're going to do another one. So I'm very curious. What are we anticipating with how many motions to dismiss meetings like this is going to happen before that exact date set for the hearing? And it gives us, I guess we can say it right now, the opportunity to weigh it and sleep over it and digest it and marinate it a little bit here and there and come to a decision on that day set for the hearing. I'm very curious. How many more motions to dismiss are we going to anticipate? Or is this the only motion to dismiss that we're going to be dealing with before the day is set for that hearing to make a decision?
Point taken, Senator De Leon Guerrero. Counsel Hogan.
If I may. Thank you, Senator, for making that argument. As you just heard from your counsel, your interpretation of the rule is wrong, but your conclusion is right. I understand why you want to make sure that no one's breaking the rules. And based on my presentation today, I don't see how you can vote any other way. Thank you.
Okay. Senator Maglonia, recognized.
Yes, based on I guess the Senate's agreement or concurrence with Senator Carl's I guess understanding that since this is not a hearing, it's okay to listen to the motion to dismiss. So, Mr. President, I'm not trying to argue further again on the issue of the prosecutor. I know what our rule says, but I also hear the House of Representatives that they responded back to you as impeachment hearing officer that they are ready to come here and join us if they are given the 5 members to be prosecutors. And I can understand where they're coming from, because in the public comment portion, each of them, when I listened carefully to them, were handling different portion of the articles of impeachment. And knowing that they're not attorneys, they don't have formal legal background, I think that it's good to for this body to really sit down and discuss that, because the rule allows only you, Mr. President, to make that decision to deny them that. But also the rules, if I'm not mistaken, has a provision there that you can actually overrule that portion of that particular rule to provide for a fair trial. So I'm saying that maybe not 5, but what about 3 prosecutors? Also, with regards to the documents and the evidences that are not in order, I know that we deny them because they did not do it in 48 hours, but then again, they asked for 30 days. Maybe do not give them 30 days, but give them 12 days. So this is something that, I don't think we need to be going back and forth. I think if we can discuss that, bring them in and let them argue why they should have 5, and let them argue why they should not have 48, but 30 days. And then we listen to them, allow them, and let's have this hearing so that I'm sure the defendant and the prosecutor won their day in court, this court before us. And that's all I'm asking, Mr. President, going with, I guess, the understanding of Senator Carl when he said it's okay and proper to have this hearing today. I'm in meeting, and I respectfully ask to allow the House to come in here. I mean, I hear a lot of accusations today. Of course, that's their role to be advocate of the defendant, but I really want to hear their side too, because I'm sure they have their side of the story. Si Zusmasi.
Thank you, Senator Paul. I recognize Senator Teresita Santos.
Thank you, Mr. President. I too agree that with this motion to dismiss hearing, we lack due process. Due process is a requirement for legal matters to be resolved. It accords both parties to be notified of the hearing, providing both parties the opportunity to be heard, and assuring both parties to be treated fairly in an impartial tribunal. In this case, there's no due process according to the House impeachment prosecutors. None of them are present before us, but we do have the impeached official defense attorney presenting his motion to dismiss case before us. Due process, Mr. President, applies to both in civil and in criminal matters. And I totally agree also with Senator Manglonia that if the impeachment prosecutors are authorized or allowed to appear as a team or a unit of prosecutors to present their case, they would have done so. And that they would have complied under Rule 5, the presentation or appearing before us to provide us with a burden of proof at the hearing. And so with this, Mr. President, I too would like to request that you consider the request that was provided to you or that was submitted to you by the House impeachment prosecutors to allow them to come here as a prosecutor or a team of 5 or a team of or a unit of prosecutors, so that we can accomplish, or we can accord them that due process to appear before us and present its case. Thank you, Mr. President.
Jesus Masi, Senator Santos. Chair recognizes Council Alden.
Thank you, Mr. President. I just have to say something here. I want to make sure I'm understanding the senators correctly. Because what it sounds like is they're asking for the Senate to break their rules, to allow the House to participate when they failed to follow all of the rules. I hope that's not what the senators are saying. But if we're talking about due process means following the rules. On behalf of Governor Torres, that's all I've been doing since I've filed my notice of appearance here. And so if we want to talk about fairness, where is the House? Why did they not follow the rules? Senators, I agree, we should not break the rules. And as you've just seen, the House has broken so many rules. I really don't see how you could disagree with my motion to dismiss. Thank you.
Thank you, Council Alvin. Recognize Senator Edith De Leon Guerrero.
Thank you, Mr. President. I do appreciate Attorney Ogden for you emphasizing that we need to follow the rules. We need to follow the law. And I took some notes of you calling out Government Ethics Act, the Constitution. And what I'm going to say is very relevant too, because, the mentioning of Representative Tina Sablan standing to gain $88,000 in the term if she ever wins, from a $32,000 salary to a $120,000 salary increase. Isn't the same statement that you have made the same should apply to our sitting senator as well, Senator Sablan, who participated in the joint committee in the drafting of the Senate impeachment rules, and reading on today's article, which neither Senator Sablan nor Senator Justo Quiriguac, who both submitted a recusal letter to the Senate President, and with respect to Senator Sablan, on today's paper that he submitted his letter on March 28, the very same day that the motion to dismiss was filed with the Senate clerk. And the point that I'm trying to make is when we place so much emphasis on ethics, the government ethics, the Constitution, following the law, following the rules, let's not forget that our very own, and look today, two are missing, not participating. Yet on the newspaper it says, and if I may quote, "I will be here." And this is from Senator Sablan's article, that he will still be present to hear the testimonies and the evidence presented, but he will not take part in the voting process. This is on today's paper. And I'm just, I will not say I'm lost. I'm just, this is just, I call it how it was called, that it's a mess with the impeachment records. Similarly, we are caught in a mess. And we're trying to swim out of it, I guess. Thank you, Mr. President.
Council Alvin.
Thank you, Mr. President. And thank you, Senator, for bringing up this issue. Because as I had just explained, the Constitution requires disclosure of any conflict of interest. And that is exactly what the Honorable Senator Vinny Sablan did, as well as Senator Husu. They announced their interest, their conflict of interest. They declared it. And that is why they're not participating today. And that is exactly why I'm saying it was illegal for Tina Sablan to be participating at the House. So under your same logic, Senator Guerrero, you have to vote to grant my motion to dismiss. I think you're seeing the issue with the conflict of interest. That's why Senator Sablan is not here today. It's because he declared his conflict of interest as required pursuant to the Constitution.
Thank you,
And to
Counsel.
be clear, Tina Sablan not only denied her conflict of interest in the news, she said it was okay.
Senator King Neighbors, did you raise your hand?
Yeah, I just wanted to clarify. Senator Paul said I said meeting. I in no way, shape, or form said meeting. Very, very clearly remember saying this is a hearing on a motion to dismiss. And then a subsequent hearing on the articles of impeachment will be coming separately. So just for the record, set this straight. I never said meeting. Thank you.
Thank you. Any other member before I see Senator Manglonia raising his hand?
Yes,
Recognize, Senator.
just to comment on the response by Attorney Agon, you are right, Attorney. I think you've been complying with the rules. The problem is, from day one, we have made a rule that favors the impeached official, and that has been my argument from day one, because they allow the impeached official all the lawyers they need, but yet they will not allow the prosecutor, not lawyers, but members of the House. That's the one of my very first issue when we deliberated on that. So while you complied, they could not comply because the rule tied their hands and put a blindfold on them. That's my opinion, and and um, and it's for that reason. Malago na yun, no. Nakararesti, Mr. President, 1 minute by finot tomorrow. Tasa o gagago, mga tsongta. Publiko ba na uzong mamalago na pagwaha no impeachment hearing, mamanananggay. Tasa rekomend na podnesti, na siguro nagwa reglamento, law tanay tsansa, sampapa na guma sa mampareta, todo sita mamalago para tatungo afa na makukusa i gobernota sa tipagwa historia pega gizota journal na si mausa za estudiante na estudanteta gi mamamayla pues taza tirele ko para ta convict pat mga ma-convict na malagwa zo nagwa kausa za ta city house manggay gini todo man mattu malago man participaw ta ikingog siya ta planta uzong ti kontesti ti menanas judge no Weissman para as judge no Ojigi Watu no taikingok dako siya tapay ni gobyerno o pitate no pues ita na ito sita tumungo na politika law na process na masirigi constitution law malag constitution ileleng na David gwa kausa na pues ito lili kumata na gwa kausa para ito tauta data ikingo sa no ungan gwaji lininya o no dikikit na tao ta fanadis pensa lo mangikwento gini na po sa lapi publiko janggi titatsogin dinansi tay mano gi man mamamayla ugwaha masi na dai gi sa lapi publiko janggi matungo na o como majoria yung guma padoto taza luano no gagagaw okay ji ling mizut ti kabali si dokumento ti lawyers lo may la fa dokumento mismo masate de nansi page may la jacob di cd pagwe no na lani latsi sti todo siya polo sa baking o gininong banda ofa na latsi za pagwe ginidekta no manisita tempo LB na uno sti legislative bureau. It's just one body, the legislative bureau. So if the house clerk cannot do it, it's our fault because that's the way we set it up. They're not. I know that House clerk, Senate clerk, there's a little bit of division there, but they're all funded under one budget, one director for them. So we just tell our director, hire 5 more people so that you can help Linda, the clerk, so she can page them correctly. That's what I'm asking. It's like we're trying to play technicality here. Hire 3 more clerks and let them help Linda and work with Doris. And, they're not going to side with anyone. They're independent bureau. So si Jus Mosi tada fa pabesangan thank you.
Thank you, Senator Manglonia. Recognize Senator Cruz.
Thank you, President Senator. Senator Poti patamong munaroslo tanaklaura amin goloke malago zo no gwa kausa lo tisinya na tayo na kabalis i kausa janggen taza ebidensya. Dene lemu pro masyafa na dokumento. Kumuta aksepta masyafa na dokumento manabakit todo. Tisinas pitata mauno gini no eji put def no first na article. Japisisu jena go malago zo loke no mapresenta i kausa. Jajigi leko gitutun. Koti mang confidential ni kausa niya ni bulan ebidensya. Go nigi loke malago i patali kabalis. Zatain na kabalis. Sa taza gini tanano malago zo na po kabalis i dokumento koski taina iafa sineda niya. Lo jangginti kabalis mogi pat sinoji man mesklaw siya i dokumento. Tay manyo na gilay no para ta ina kabalis your truzi pata mix is otanu I house and senate kala namang gagi koti kala ta pa sini judge na zo fani to mizu zo raji zo pumar security I defendant tita geno na machigenya dosis na guma jadi video ga no fair zan equal opportunity data ina kabalis ko saki munga na tafan masangoni ni publiko na titatunga fa ta sotsogi saman parewita timan lawyer do jangin ta ina I ebidensya data ata ni article sempi tatungo klaro ko magahit na makomiti eno na offense sa jangin eja talili article sa taza ebidensya po sinupotta na tisinya na tapatawlong na unggan magait no TFZ masya taigi tia constitute ejo na offense tisinya tagano na klase debi li kabali si ebidensya siya ni sinipopotta asupopotta no na kada uno gano gi articles ezi kina precisus tina David kabalis speciotro David matatizi na I rules sa jangin tu tatizi rules ni ngayan no safu mo na fata keketsugi gini jangin masya fa patasoge that it abide by the rules believe me na sempi afa chichota no am void eno si Jesus masi
Thank you, Senator Cruz. Senator Hoku.
Jesus Mercy. Again, no, Mr. Chairman. Malago azo pabay passion loki izota abogado gi umazuday komite na. Zanginin fin counsel. Zanginin fin in the event, okay, that the appointment of the president to a member of the House to be a prosecutor during na hearing, called uno na prosecutor binar huzum or pinihibi para fangoni sindalunya magi girantin I hearing para inazuda zangin siya kaso nagwahak tisina ha opi giwiza mismo para opi I abogado I otro banda kausinya manggagi sindalunya para ofaisin hafa na respuesto para sangan na pagwiza oficialmente o opitati abogado yung banda kau pinihibi zangin sa kaso mo na magsepta inapunta ni presidente. So ata ni sila, Mr. Chairman. Pareho zangin gi kutin I Commonwealth court. Guahanay firm hukoni para defendizo. Lo gialomeste na grupo na abogado uno para representazo para kwentos gamyan ni kote. Lo sinya by koni otro siya na abogado gifiono. Na sinya zo loke mabibisa zangin sa kaso onisita azudo ginin siya. Kautimali izota counterpart gi house that they can accept money appointment. So kung niya niya attorney durante hearing na para defendi otro na abogado na para uguat gomento gi haji dinansya haji latse na hita patafatina na desisyon como hita manzuri gini pao. Often na tima accepta tayo mon na zangin siya kaso. Na sinya matsogo Kung mahaso pati mahaso na sinya matsogo tayo Kanso Bermudez sinan.
Kung malago na ba opini question mo?
Sa magkomprende na.
Sa ginunatan na rule 7 Rule 7B Rule 7 na ilang ifunin na prosecutor pumapunta. I-speaker dang senior speaker. Pes chairperson House Impeachment Committee dang senior gwi pues rule lang niya presidente pumapunta. Pues a decline the speaker, a decline the chairman.
Counsel, I think the
chairperson.
question is
Kaya
not that.
May
The
foto ka
question-
ano. Pues, iminatres na mapunta, kala na decline na lo, i-question na si Senator Hokuk. Ang sa kaso na accepta, uno gedi tres, sinya ako ni mogi lang niya. If you know English, may select staff to assist in prosecuting the articles of impeachment. The role extended the impeachment prosecutor staff shall be limited to House legal counsel, the trained lawyer, and or other House employees. Stisha na sinalunya sinya kundi magiza maajuda prosecutors ang uno gitres tatidzi o dini presidente za ma-accepta. Loti ma-accepta ni.
Thank you, Counsel. Reason I know they could have accepted so much of it to move this hearing forward with both the respondent and the prosecutor to be present. While we sit and listen and then render our finding based on their argument. Thank you, Mr. Chairman.
Can I follow up question
Thank you,
on
Senator
that,
Poe. Hold on,
Mr.
because
President?
I wanted to recognize Senator Santos first. Senator Santos.
Yes, thank you, Mr. President. And so perhaps the reason why the House decided to prosecute as a team or have a unit of prosecutors is because we have 6 articles of impeachment, and perhaps they decided to dedicate each prosecutor for each article of impeachment, and that's how perhaps they're going to handle or proceed with the presentation of the articles of impeachment here in the Senate. And so that is my assumption. Now we go back to Rule 9. If only Mr. President, you granted the extension that was requested by the House Clerk to submit the voluminous records on the articles of impeachment, perhaps they would have been in compliance with the submission of those records and the audio recording and so forth and so forth. Unfortunately, that was not granted. And so again, Mr. President, I ask that you consider this request so that we can have the House impeachment managers or prosecutors here, so we have a full trial. I think the people of the Commonwealth is expecting us to conduct a fair and a just trial regarding these articles of impeachment, and not just having the defense of the impeached official here before us. Thank you, Mr. President.
Thank you, Senator Santos. And for that point that you reference about the president or the presiding hearing officer given the consideration of the extension, maybe I'll yield to Council Villagomez to go to page 7 and run by that in page 7, particularly on Rule 9C, so that it's understood the manner in which the time frame that the prosecutors were given more than ample time to address the issue with the impeachment record. So, Council Villagomez, may I recognize you now to read on that.
Pursuant to Rule 9C, the House Clerk was given 14 days to transmit the articles of impeachment. In addition to that, under Rule C1, the House Clerk was given the opportunity to submit a written notice for a 7-day extension, which the House Clerk did in this case. So the House Clerk had a total of 21 days to prepare the impeachment record pursuant to these rules. And the requirement of the House impeachment record, the organization pursuant to Rule 9A states that the House impeachment record shall be consecutively paginated, means it shall be numbered in order, and then contain a table of contents identifying the page on which the part begins, and 3, be organized in first by article of impeachment and second by chronological order. So this is the organization of the required organization of the House impeachment records. As stated, the House impeachment record was transmitted, I believe, on the 19th or 20th day, the day before it was due. Correct? Yes. Something to keep in mind. So the House clerk had 21 days, but also under Rule C, number 2, it says no later than 3 days prior to the expiration of the 7th day, the House clerk can also submit a written request for another extension to the Senate President, which the Senate President can, which has to be approved by the Senate President. The House clerk did not take this opportunity to ask for a second extension. They only exercised the first extension. So when the Senate clerk received the articles of impeachment, and the Senate clerk, along with the Senate LB staff, the legal counsels, the legislative assistants, and the general clerk, we helped the Senate clerk review the articles of impeachment to make sure they comply with Rule 9A. At that time, after our review, the Senate clerk transmitted a letter down to, or the Senate President? Oh, no, sorry. It was the Senate clerk that transmitted the letter down to the House, informing them of the deficiencies, and I think it amounted to about 30 pages. Basically, the entire record was not in chronological order. Yes, it was organized by Article 1, 2, and 3, but the evidence, the documents, they were not organized by date. So you might have a document that is, the first document is dated June 5th, and then the second document is dated February, and then the next one is November, and then we're back up to January. So it wasn't in order. It wasn't chronological order. All of them were that way. So just the basic requirement of being in chronological order, that the House impeachment record didn't comply with that requirement. And then consecutively paginated, again, the rules the record when it was first transmitted to the Senate, the first number that we got was 7,000 plus. So right off the bat, again, it was not in compliance. So I believe when the Senate clerk received the House clerk, when the House clerk received the Senate clerk's notice of the deficiencies, you have to go to the same rule, Rule 9E, 9E2, which says if the House clerk, Rule 9E1 states that the House clerk has 48 hours to correct the deficiency. So that was the communication from the Senate clerk to the House clerk. And then the House clerk replied asking for a 30-day extension. But unfortunately, the rule doesn't authorize, once you submit the record to the Senate, the rule doesn't authorize any extended extension to correct the deficiency. The rules only authorize 48 hours, which the Senate clerk was not able to correct the deficiency within that 48-hour period. But there is nothing under the rule that would give the Senate President the authority to extend that 48-hour period. The Senate clerk should have taken advantage of the second extension opportunity after the 21 days. There was an opportunity for a second extension. The House clerk could have taken that opportunity to request for additional time, again, to work on the House impeachment record. And so the President replied with a letter declining the request for the 30-day extension because the Senate impeachment rules do not provide for such an extension.
Thank you.
That's all.
Thank you, Council Villagomez. Before I recognize Senator Paul or Senator Edith Leon Guerrero, if I may recognize Council Ogun first. So,
Thank you, Mr. President. I'd just like to address the fact or the comment that Senator Manglotnia made that the rules are unfair. If the House submitted their impeachment record correctly, I would have gotten 14 days to review those thousands and thousands of documents. I would have had to abide by the same set of rules that they failed to follow. So if we're talking about fairness is following the rules. Fairness is complying with the law. Thank you.
thank you. Senator Paul, Senator Edith, she's been raising her hand. So,
Raised my hand before her.
okay,
Mr. President.
so I'll recognize you now, Senator Paul.
Thank you, Mr. Edith, Senator Edith, for yielding. I want to answer the question clearly. I think our legal counsel didn't answer clearly the question of Senator Hokuk. This is the answer for the question of Senator Hokuk, and I read verbatim our Rule 7B. The impeachment prosecutor shall be a member of the 22nd House of Representatives and may select staff to assist in prosecuting the articles of impeachment. The impeachment prosecutor's staff shall be limited to House legal counsel and or other House employees. I think Senator Victor was asking, can other House members be assisting the prosecutor? No, no House members can be assisting. And there's going to be only one prosecutor, and it's only the lawyers or House employees. And the impeachment prosecutor on subsection C of Rule 7, I quote, the impeachment prosecutor shall be the only person responsible to present evidence, ask questions of witnesses, make motions, and address the Senate and or the committee. So no, he could not invite the other House members. And yes, I understand where our counsel is coming from, that they had ample time. But let me say that from day one, they didn't know who was going to be the prosecutor in the House. And I think that is a key appointment, that we know who are the prosecutors, because if we don't know who are the prosecutors, then we depend on the House clerk. And as you know, the House clerk is under our legislative bureau. Only one director, Mr. Director Perry Tenorio, and then you have a Senate clerk, a House clerk. So all I am saying is to understand their limitation as far as employees that can do this correctly, because I'm sure that our House clerk and our Senate clerk do share information on how to do it correctly, how to get on, how to structure the documents and page them. So I'm just saying that sometimes they have lack of manpower, and it's for that reason that they have to coordinate. But again, Mr. President, I don't understand the Senate rule here, but the Senate rule do allow that it can be suspended or amended by a majority of the members of the Senate by a record vote in the interest of justice. So I believe that if the majority of this body agree, as long as it does not weigh toward one party or the other, because in this case, I think that the House's hands were tied in the back in the beginning, because they still don't know who are their prosecutors. They don't know whether that one prosecutor has to learn all the other articles, because the House again designated certain members to handle particular articles of impeachment even during the hearing process, and it's for that reason that again they're asking us for 5 prosecutors to do smasi.
Thank you, Senator Manglotnia. And before I recognize Senator Edith, we are still, I hope that we're still in order to entertain the motion to dismiss presentation today. And I understand the passion with regards to this particular matter, but I want to just circle back and remind the members that that's why we're here this afternoon. So, Senator De Leon Guerrero.
Mr. President. Preciso stige. Zagof malaguzo. Nagwa onru. Ganyan naguma. Man matatat sungit pago para ta ekungog emotion to dismiss. Ta debati is otta mismo rules, the impeachment rules. Mala ta fangwentos por facto. Elect niya i-attorney i gobyerno. Uno gizon niya siya no arguments na i-kandidato gas no Representative Tina Sablan. She gets free media campaign, direct savings for the Democratic Party and for Tina. 88,000 salary increase for Tina. Malaga ta fangentos put onro. Ane pago una punta i dos na joint committee ni poro matugi i impeachment rules. Masusedi nigi gi February 25th, 2022. Man meeting i joint committee. Zama pasa gi joint committee i impeachment rules. Después man meeting it ni Senate et zigit na mapasa i impeachment rules. Without any no ma-accepta na amendments ni maprosito ginengwaw dyan si Senator Paul. Di mismo ora pago, mangikan to sit loki put government code of ethics, a constitution. It mismo tempo, gi article. Dyan din para tafangwentos put onro, demokrasiya, afa proprio po matsogi. New hafa na kotti. Gwa defendant, dyan gwa plaintiff. Lo ipunto mas ganyan ni preciso, onro. Galomesti mismo naguma sa we are the trier of facts, despite the fact na todza impeachment records. We're going to base ourselves on what has been presented today, motion to dismiss, but a lot of the arguments is premised on somebody gaining something, violation of Constitution, Open Government Act. Loyet para tatarabiray luta, zamunget umatan may sayit gispeyus ane mismo hita, galong gumata imanggat songta, man matatsong loki, zama violate i code of ethics, ti madeklara izonya conflict, for example. Masusedi i meeting i February 25th, 2022, Council Agban. The declaration based on the newspaper today was not submitted to the Senate President by Senator Sablan. It did not happen until March 28. That is 1 month and 3 days. Is that proper when we want to call out code of ethics violations on someone else? Yet within our own home, we have our own violations too. And that's the point that I'm trying to make. We need honor in order for us to move forward. We have to look ourselves in the mirror too. Amongst ourselves as members, 9 members of the Senate, is there honor in what took place on February 25th? And then a month and a couple days later, a declaration of conflict? Where's the honor in there? Yet we have the audacity to call somebody else out as gaining for whatever. And I'm not saying that to, put more points on the other person. No. Honor, process, democracy, respect for law. Fairness is following the rule, your exact words. Fairness is following the law, your exact words. Ourselves, in this very house, we don't follow it. How is that going to be called fair and honest and not a violation of code of ethics? That's honesty. Thank you, Mr. President.
Thank you, Senator De Leon Guerrero.
Mr. President, I can respond.
Council Ogun.
Dispensa lo tigof pausen zugi finun so I'm going to speak English.
Proceed. That's
The Constitution, Senator, requires disclosure, plain and simple. Senator Vinny disclosed this conflict of interest. Senator Vinny disclosed his conflict of interest, and Tina Sablan didn't. And using your same logic, Senator, is it onerous for Tina Sablon? You saw that that PowerPoint presentation of her extensive participation, her extensive influence on this. So using your same logic, are you saying that the House did the honorable thing? All I'm asking is for fairness for my client, for Governor Torres. And fairness is following the rules, once again. And that's all we're doing is following the rules. And all I'm asking is that the House follow the rules as well. I hear the senators saying they never got the chance. They had the chance. They had 3 chances. I've been working so hard for this, and I expect them to do the same. And so when they don't follow the rules, and I hear you guys asking them to give them a chance, I really do find that concerning. Thank you.
Thank you. Okay, I'll recognize that. You respond.
Thank you, Council Elgin. What is proper is for one to declare its conflict before even that joint Senate committee meeting was called to meet on February 25th, 2022. Not participate in the drafting of the impeachment rules and then adopting it within the joint committee, right? That declaration of conflict should have happened before February 25th. And that letter that was submitted on March 28th, it's after the fact. Thank you.
I'm not gonna continue this
Thank you.
exchange I want to kind of circle back again with regards to the reason why we're here. And again, I understand the passion that we keep calling out the lack of representation from the initiators of the resolution, but I appreciate that very much. Listening as someone up here, just monitoring and listening to the exchanges. But I do want to circle back and remind everyone that we're here today to take under advisement all the presentation, the exchange between the members and the council representative, representing the respondent. And then, as I stated earlier, we are not going to be voting on any matters today. We will take everything under advisement, and I will be calling, likely be calling a date with regards to the Senate hearing to entertain, to consider what was presented to us today. Senator Cruz, you were raising your hand, sir. So, I don't have any particular question. If there's no other members, I'm going to call for recess, or aka adjournment.
Mr. President,
Go ahead, Senator Po.
yeah, I want to ask a question, whether it's proper. I want to make a motion for this body to discuss or pass, hopefully, that we give the opportunity to the JGO chairman and the impeachment committee chairman in the House, just like we did today. Make them sit there and let's question them about all the issues raised by the attorney. It's not a hearing, but I think it will be information gathering, and we can then feel much better carrying out our constitutional duty with this impeachment process. So at this point, if I'm in order, I so move that we invite the House chairman of JGO and impeachment committee before this body for open discussion. So move.
Senator Po, can you, before you make that call for a second, I would like to, Council, if I'm referring to the right order on the rules, I would like to ask everybody that we clear the room, only the members, and I'll call for a short executive or session, members only session. Thank you. we're back into our hearing, or session, or hearing. Before I requested for a recess, there was a standing request by Senator Manglonia making a motion to making a motion that is not necessarily part of the hearing process today. And also, it appears that the motion that he was offering must and needs to be entertained during a Senate session, in which this is not a Senate session. So the chair hereby disapprove his motion in that regard, for that mere reason that I just mentioned. So again, Senator Poe, I made that very clear already, that I will not be entertaining that motion simply because of that fact.
Just a follow-up question to President.
Go ahead, Senator Poe.
Yeah, so if I cannot make that motion only in a Senate session, I understand that I can make that in the Senate session.
In the Senate session, that's where we can entertain in rules, changing some of the rules, the Senate rules, or in this case, impeachment rules. But in this case, it's not permissible. So I would like to ask that we move on from that question. And if there's no other question related to the presentation, I wish to go to the next item. So with that, and before I entertain item number 6, I would like to make a formal announcement that we will be having a session to entertain the presentation today, and that will happen on April 22nd at 10 a.m. And that's Friday, April 22nd, 10 a.m. As I cannot and I would not know what the outcome of this presentation, I can only schedule that in the event that we arrive with a decision, taking under advisement the presentation today, and that will be entertained on the Senate session. So with that, and of course, I'll be making the formal announcement by in writing too. So with that, again, I recognize Senator Victor Hokuk to offer a motion to adjourn this meeting. There's been a motion offered for adjournment of the hearing on Senate hearing on the motion to dismiss the articles of impeachment. It's been seconded. Discussion. All those in favor for adjournment of this hearing, please say aye. All those opposed say nay. Motion carries. This hearing stands adjourned.